Chapter 7 of the liability of the obligor generally is surety. Upon a breach of the condition, the penalty of a bond becomes the debt in law, and is the true measure of the obligor's liability. It has, indeed, in one or two instances, been held, that damages might be recovered beyond the amount of the penalty, but it seems clear from other authorities that both in law and equity the obligor is not answerable beyond the penalty of the bond and costs. Notwithstanding the obligee may have sustained damage exceeding that amount, and upon payment of the penalty and costs, the court will order the obligee to acknowledge satisfaction on the roll. But when a judgment is recovered on the bond, and an action is brought on that judgment, interest may be given in the nature of damages, beyond the amount of the penalty of the bond. At common law the obligee might have had execution for the whole amount of the penalty, though far exceeding the sum really due, and the obligor could only obtain relief by application to a court of equity. To remedy this inconvenience, the 4 An. c. 16, s. 13, enacted, that if at any time pending an action on a bond with a penalty, the defendant shall bring into court, where the action shall be depending, all the principal money and interest due on such bond, and also all such costs as have been expended in any suit or suits in law or equity on such bond, the money so brought in shall be deemed and taken to be in full satisfaction and discharge of the said bond, and the court shall and may give judgment to discharge every such defendant of and from the same accordingly. Where, however, the bond is conditioned for the payment of a sum of money at a future day, and interest in the meantime, or if it be conditioned for the payment of an annuity, or of money by installments, and the bond becomes forfeited by non-payment of interest or of the installments, in these and similar cases the courts will not stay proceedings before judgment, but will permit it to be entered for the penalty of the bond, which will stand as a security for the growing arrears, and the execution will be restrained to the sum actually due. The liability of sureties will never be extended by implication, but the condition will in general be construed strictly in their favor. It has been established by a series of cases that where a surety is bound for the faithful services of his principal as clerk to one or more individuals, the obligation will not extend to any subsequent change, without an intention to that effect clearly appears upon the face of the bond, for it is presumed that the surety might be induced to enter into such a security in consequence of the confidence which he reposed in the integrity, diligence, caution, and accuracy, of one or more persons, and which reasons might not equally apply to other individuals. Thus, where the condition was that a clerk of the plaintiff should, during the time he continued in the service of the plaintiff, keep just and true accounts of all monies received and paid, and from time to time pay all monies which he should receive belonging to the plaintiff into his hands, and the obligee afterwards took a partner, it was held, that the defendant was not liable for a breach of the condition subsequently to the partnership. So where the condition was that a person whom the obligee had taken as a clerk should give a true and just account, and pay to the obligee, his executors and administrators, all money which should be from time to time received for and on account of the said obligee, his executors and administrators, and the obligee having died, the plaintiff, his executor, carried on his trade and retained the clerk in his service, it was adjudged that the bond was given to the obligee as an indemnity that the clerk should be faithful to him, and should pay all monies received on his account to him or to his executors, and it was not the intention of the parties that the bond should be extended beyond the obligee's life. In like manner a condition to pay all sums advanced by 3 partners, does not extend to an advance made after the death of one of them and a new partner taken in. And where a charter is granted to a society not previously incorporated, the bond ceases to exist, notwithstanding the same persons remain governors, for the original society is thereby destroyed, and in judgment of law a new body is constituted. The doctrine established by the above cases is equally applicable to a change of the obligors, and therefore, where several partners are bound with condition to pay money advanced to meet bills drawn by them, the condition does not extend to bills drawn by the survivors after the death of one or more of them. And where a surety undertakes that his principal shall account for all sums of money received by him for the obligee's use, the guarantee does not extend to sums received by the principal after he has with the obligee's knowledge taken a partner. Upon the same principle, if a bond be given to the sheriff by a jailer, conditioned for the safe removal and conveyance of prisoners under the authority of writs of habeas corpus, and the sheriff on a particular occasion directs his warrant to the jailer and a bailiff specially appointed for that time only to bring up the body of a prisoner, in the event of the prisoner escaping from the custody of the bailiff, neither principal nor sureties are liable in an action by the sheriff on the bond, for in such case, the principal would not be considered as acting under his ordinary appointment of jailer, but under a new and different authority imposed upon him by the sheriff himself. If, therefore, it is intended that the responsibility of the surety should extend to any subsequent change, such intention should be clearly expressed upon the face of the instrument. A distinction however has been taken between the above cases, and where the security is given to the house or firm. In the latter instance a change in the persons composing a partnership will not operate as a discharge of the liability of the surety. Thus, where a bond was given to the trustees of a certain company, conditioned for the faithful performance of the duties of a clerk during his continuance in the service of the company, it was held that the bond might be put in suit notwithstanding any intermediate change of the original holders of shares by death or transfer. And where the condition, after reciting that a bill in equity had been filed against two persons, was that the obligor should pay all such costs as the court should award to the defendants on the hearing of the cause, and one of the defendants died before any costs were awarded, it was held by 3 of the judges, Abbott, C.J. Dissentienti, that that fact could not be pleaded in discharge of the bond. It has been before observed that the extent of the condition of a bond may be restrained by the recitals. This doctrine has been uniformly acted upon in favor of sureties. Thus, where it appears by the recital, that the defendant is bound as surety for the due performance by his principal of the duties of any office, the liability of the surety will be limited with reference to the nature of such office. If the office be an annual one, the surety will only be answerable during the period of the current year, notwithstanding his principal continues to hold office for a longer time. And though it does not appear on the face of the bond to what period the office extends, the defendant may nevertheless show by pleading that its duration is limited to a particular time. But if the duration of the office be prescribed by Act of Parliament, it will be unnecessary to plead it, for the courts will judicially notice it. Thus, where the condition of the bond, in which the defendants were bound as sureties, recited that their principal was, on a particular day, appointed collector of the church rate of a certain parish, by virtue of which office he was empowered to collect and receive all such moneys as were rated and assessed on the inhabitants by virtue of the said rate, and for which he was accountable to the wardens of the grand account, and the defendants were bound for duly accounting by their principal of all moneys collected and received by him on account of the above rate, and also on all and every other rate or rates thereafter to be made or collected by him. The defendants pleaded performance by the principal in the terms of the condition, to which plea the plaintiffs replied, that the principal was on a certain day appointed collector of the church rate of the parish for 1 whole year then next ensuing, and at the expiration of that year was again appointed, and so on from year to year for a certain space of time. It was held upon demurrer, that as the replication admitted the office to be an annual one, the defendants were only liable during that period. The principle here laid down is not confined to cases of a surety to the person holding the office, but extends also to his deputies. Thus, where the condition of the bond was, that a collector of the poor rate should, from time to time and at all times when thereunto required, produce to the church wardens and overseers, or to their successors, all such sums of money as should come to his hands pursuant to and in the execution of his office. It was held, that as the offices of overseer and church wardens were annual offices, the office of collector, who was in the nature of their deputy, must be confined to the same period, and therefore the obligor was not answerable for monies received by him on account of any year subsequently to that in which the obligees were in office. It does not however necessarily follow that the deputy of an annual officer must be an annual officer himself. In the last mentioned case there was nothing to show any intention that the deputy should continue in office a longer period than his principal, but where the condition of a bond recited a statute, and that in pursuance thereof the principal obligor had been appointed by the church wardens and parishioners of a certain parish collector of the poor rate to be levied and raised in the parish, and the condition was, that the collector should account for all monies so collected and received by him by virtue of the statute, and it appeared that there was nothing on the face of the statute to limit the period of office to a year, the bond was considered to extend to the whole period of time during which the principal obligor continued in the office of collector. A bond being an instrument under seal, the obligation created by it can only be discharged by an instrument of an equally high nature, and therefore the lackey of the obligee in not calling upon the principal for payment so soon as he might have done is not an estoppel at law in an action against the sureties. Neither can the giving time to the principal by parole agreement be pleaded in discharge of their liability, though that circumstance might induce a court of equity to interfere, or would be a ground for an application to the equitable jurisdiction of a court of law, which will always be exercised where the surety is placed in a worse situation. In the event of any one surety being compelled to pay the whole sum recovered, he may maintain an action against his co-surety for contribution, even though he had given a subsequent security to the obligees, under which he paid the sum named in the bond without the knowledge or consent of such co-surety. And if several persons are bound as sureties in separate bonds, and any one of them be compelled to pay the whole debt, the others are liable for contribution in proportion to the penalties of their respective bonds.